Right. So the question is, so we had to make so in Florida, you know, if you're on trial for a crime, it has to be a unanimous verdict. That's how it should be. That's how it always is. So say you're on trial for first-degree murder, you're convicted. Then it's a death penalty case. Then the jury would vote on whether to give the death sentence or not. And historically, in Florida, if 8 of the 12 jurors said death, you could get capital. Our old liberal Supreme Court said that that was somehow unconstitutional, and so the legislature changed it to say, okay, you have to do unanimous for the penalty. And the current Supreme Court reversed that. And so we were in a situation where the legislature hadn't changed it back. You had the Parkland situation where this guy massacres these students and teachers. The only appropriate punishment, in my judgment, would be capital. Now, it's fine if you don't agree with capital punishment. A lot of good people don't, but it is the law in Florida. And so my view, the worst of the worst, you have to give that. Part of it's to deter other people. Part of it is just that's the only appropriate punishment, and I think the victims deserve maximum justice. But what happened was they fell a juror or two short on that. And the question is, you know, were these jurors that were really not inclined to give it under any circumstance? And if you have a unanimous, you have one juror that can basically nullify what the rest do. No question about the guilt. Yeah, the unanimous, you got to be unanimous for guilt. So these are guilty people. But then the question is, going forward, if you have 8 of the 12 that agree with that, you know, that really should be enough to move forward, given that some people could get on the jury who really aren't intent on ever doing capital. So we did the law. Part of it, the Parkland families were really supportive of it. Now the question is there may have been, I signed the law a couple weeks ago, there may be cases where the crime had already been committed, the individual had already been charged, but they haven't gone through the trial yet. So now when you go through the trial, is that 8-4 threshold going to apply? And basically it's just a question of law. I think it does because it's a procedural change, and usually procedural changes are fine. But they'll file motions, it'll be litigated, and then you'll go from there. So my anticipation was, yes, it would likely apply to pending cases just because procedural rules do. You can't change a substantive rule in the midst. So say you committed conduct which clearly isn't criminal. If the legislature then criminalized it after you committed it, they can't go back and say you committed a crime because you didn't at the time. And so that's a difference between substance and procedure. So I think it's going to work out and it'll be fine. I think so. I just started reviewing it yesterday. I think basically it's you know, you're going to treat a roadworthy golf cart like you would treat an automobile, and that's something that probably makes sense when you're on those roads. I know there have been problems with it, so I haven't made a final decision on it, but I would say that I'm favorably inclined. Okay, guys, thanks so much. Appreciate it.